planning on getting married and you just don't know which one you want to go for. And there's a myth I used to hear people say a lot. They say if you marry at the registry of an high court, when you are getting a divorce from your wife, you share the property into two. So because of this, a lot of men they don't want to marry at the registry, and a lot of women also they want to marry at the registry. I don't know why. They seem to be planning on that what's it called divorce, getting their split during divorce. So it is a myth, and we are going to be breaking everything down this afternoon. All right, so I used to tell my men, I used to tell my kings out there, if you want to get married, the best way you can get married is actually marry under the act. That's your statutory marriage, and there's you don't need to fear and say, oh, she's going to take half of my property. The law has never prescribed that your wife, upon breaking up of your marriage, would be entitled to half of your property. I don't know where that rumor came from, but we are going to be digging deeper. It's very, very obvious you will not be able to complete everything this week, but wherever we're able to get to, we will continue next week. All right, so going back to the types of marriage, I mentioned we have customary marriage and we have marriage under the act, or what we call statutory marriage. And customary marriage is actually the act, or what we call statutory marriage. And customary marriage is actually divided into two. When what we call introduction, or what we call engagement, when you carry the tubers of yam, the goat, and you pay the dowry to the family of your wife, you've done what we call customary marriage. And that marriage is valid. You can stop it at there. You don't really need to go to church. You don't need to go to high court registry. It is valid the moment you pay the dowries of your wife. You seek the consent of your wife, and you seek the consent of our relatives, our family members. Your marriage is complete. So that's what we call customary marriage. And what are the advantages of this customary marriage? You can marry multiple wives. So it is actually very good for men who have the art of polygamy. If you know you are sufficient enough, you have the financial, sexual, and physical capacity to marry multiple women, you can go for customary marriage. So as a woman, if your husband is actually introducing customary marriage to you, he says he just wants customary marriage, you should prepare your mind to the fact that he might want to marry many other women after you. It is valid. It is accepted. So now let's come to the other form of marriage. People who also contract Islamic marriage, it is categorized under customary marriage. Islamic marriage is mostly categorized under customary marriage. So that's why as a Muslim who has married under the Islamic principles and precepts, you can marry as much wives as you can afford to. So the second marriage is what we call marriage under the act, or statutory marriage. It is actually when you marry at the registry of an high court, or when you marry in a church. Church wedding and high court wedding are the same thing. This is something that people don't get again. People think there's a difference between court marriage and church marriage. There is no difference. Either you go to court or you go to church. What you've done successfully is court marriage. It's the same thing. And what is the implication of court marriage? It is actually a very beautiful marriage. And the first thing is, you cannot marry multiple partners. Once you're married to one person, you need to stick to this one person till death, or an high court do you apart. Till death or an high court do you apart. In case you want to join the conversation or you have questions on the program this afternoon, you can call us on 0704 700 3969. You can also reach us on 0704 700 2969. So all right, so back to our discussion. When you marry in the church or you marry in a court, you've done what we call statutory marriage, or marriage under the act. And I said you cannot marry multiple partners. So what's the implication? If you marry in a church or you marry in the court and you want to marry a new wife, or you want to marry another husband, if you go ahead and you do it, you are liable to a crime we call bigamy. And the punishment is 7 years imprisonment. So as a married man, as a married woman, if your partner actually went to marry another partner after your initial marriage that was contracted in a church or in a court, they've committed the crime of bigamy, and you can make a report and have them sued. But I don't really know if you would want to see your ex-husband or your ex-wife languishing in jail. It's a very tricky situation. It could be the father of your baby, the mother of your children, and but of course the law is the law, and the law does not really care about emotions. The law says when you marry under the act, when you marry in a church, when you marry in a court, you don't marry another partner. And that doesn't mean you have to stick to that marriage forever. Don't forget, you can seek for divorce. So if you want to marry another person after marrying in a church or after marrying in a court, you need to go back to the court. And don't get it wrong, even if you marry in a church, you cannot go back to that church and ask your pastor to dissolve your marriage. The Marriage Act has already said only a judge of an high court, can dissolve your marriage. But it's very interesting because for customary marriage, there are two ways you can dissolve it. You can dissolve your customary marriage in two ways. The first one is you just carry all the yams, goats, whatever the family, the bride's family have taken from you. You take everything back to them, to the elders of the family, and whatever requirements they are asking of you, you make sure like you meet all their requirements. You return the dowry, and so that way you can actually dissolve a customary marriage. Another way you can dissolve a customary marriage is to apply to a customary court. That's why we have customary courts. You can apply to a customary court. They can help you dissolve a customary marriage. But when you marry in a church or when you marry in a court, which is the same form of marriage, if you've been following what I'm saying, you have to apply to an high court. You have to apply to an high court to dissolve your marriage. And you know, I've heard of a very funny situation where a pastor would write a dissolution letter for couples. Like, you are a pastor of a church. For pastors listening to us now, what you've been doing is illegal, it is unlawful, and it is invalid. It is null and void and of no legal effect in the eye of the law. A pastor or an imam has no right to break your marriage. So I also heard there are some Islamic clerics that would pronounce the dissolution of marriage on married couples. This is actually not legal. It is not recognized in law. So if the person that dissolved your marriage was your pastor or your imam, your marriage is still actually very active. It is very active. It is not valid. But let's come to the question of property, which is what a lot of people really want to know. A lot of men want to know, what happens if I divorce my wife? Are we to share the property 50-50? What happens to my property? I know my kings are actually listening. They want to know. And my queens are they are also listening. They want to know. Maybe they can get a bit of that man's property. Stay tuned. So actually, during the dissolution of a marriage, it's not like automatically the court gives 50% of the property to each of the parties. The court will actually look at the contribution of everyone. That is why it is very important, even as married couple, when you are building together, you should find a way to keep records. Keep records of your contribution to the marriage. When you bought a car, how much was your input in the car? When you built a house, how much was your input during the building of the house? So don't expect that you did not contribute anything significantly during the marriage, but automatically you want to break up with the man and you want 50% of the property. No, the law will not allow. That's a daylight. I contributed to the properties of my husband. Well, you can prove it through your bank statement, through testimonies of witnesses, and receipt of money and transactions or communications between the two of you. That's why it is very, very important and very good to keep records. It is very good to keep records. And for some properties, there are properties that you can manage together even after divorce. It's not necessary that you split everything. Let's say the two of you started a school and now you are divorcing. It doesn't mean you have to shut down the school. It doesn't mean you have to kill the business and everything you spent a lot of effort to put together. So you can still make an agreement. You can reach an agreement on how to manage your properties together jointly even after the dissolution of your marriage. And here's something, don't forget that under our customary law, if you went for a customary marriage, it used to be the situation in the past that women are seen as being unable to own property. Under our culture, which used to be a little bit barbaric, sorry to use that language, they believe that a wife is the property of the husband. So if you are breaking up with your husband, if you are dissolving your marriage under the customary law, since you are the property of your husband, you are not entitled to anything because your husband owns you in the first place. But that's no more the situation under the modern law. The court will not allow a man to treat his wife as a mere property. Rather, she will be treated as a co-owner, as a joint owner of those properties, in as much as she can prove that she actually contributed her own quota to those properties in question. You are planning to divorce or you just divorce your wife, you are fighting on custody of your children, you want your children to be with you, anything, you can call for clarifications on 0704 700 3969. You can also call into the program on 0704 700 2969. So we are actually at a very important part of the program. I would implore you to listen very carefully. There's something we call maintenance in law. That's even after the end of your marriage, while the marriage was still very active, you had children and the family was happy and everybody were doing good together. Now the marriage is splitting. What happens to the children? Who takes care of the children? And who actually has custody of the children? There is a myth that the male child will go with the father and the female child will go with the mother, which is a very big lie from the pit of hell. There's another myth that when your children are under the ages of 7, you place them under the care of the mother. The court will automatically give them to the mother. But when the children are grown-ups, the court might give them to the father. Is there any truth to this? We are coming. Saw each other and you decided to get married and now you are breaking up, and so the first thing is the court or the law will protect these children to the fullest extent. And who gets custody of the children? Is it the husband or the wife? The court will look at several factors, starting with the gender of the children, the age of the children. So when the children are actually very young, there is more likelihood, but not certainty, more likelihood that the court would like to grant the children a custody into the custody of their mother, because naturally women are very good at nurturing and taking care of. And apart from the gender and the age, the court will actually also look at the financial capacity of the person taking custody to really take care of the children. The court will also look at the mental capacity. So let's say there's an husband and wife and they are divorcing, and who is going to get the children became an issue. And it can be proven that the mother, the wife, has mental problem. Of course, the court will not grant custody of those children to her because she could hurt them, she could kill them, she could maltreat them. So automatically custody does not go to the female, automatically custody does not go to the male. It is the situation and the fact of the case that will determine who gets the custody of the children. And what are the things the court will look at? I mentioned age and sex of the child, emotional bond and stability, if the children have been used to a particular partner, maybe the children have always been living with their mom and the father has been abusive over the years, the court will be very reluctant in granting custody of those children to that abusive man. So the court will also look at the moral and mental environment of the children. And there's a case of a couple that wanted to break up, they wanted to dissolve their marriage, and the man had actually been sexually abusing the children even while the marriage was on. So you cannot expect the man to keep custody of these children. There's a whole lot on this topic, so I guess we are going to be ending it here today. We'll continue from here next week. Don't forget to join us 2 o'clock Wednesday on Legal Hour on Oxygen 96.9 FM. My name once again is Darasimi Okwefetim, your favorite lawyer. Take care of yourself.
Your station, your heartbeat. Oxygen FM 96.9 Ibadan.
Good afternoon to everyone listening to us again. It's an